Hello, everybody. Welcome to the Bradley J. Show. Have you noticed ring cameras? The idea of ring cameras is these surveillance cameras on people's doorknobs. I started to wonder if that is legal in Massachusetts, really. So I started checking around. I thought I'd check in with Mike Coyne of the Massachusetts School of Law, see if he knew anybody that could be an expert on this. He said, "Yep, I do. I'm assigning Mick, my son, to talk to you about this because he is qualified and he's the technology director of the Massachusetts School of Law and he's an attorney. I think that's super interesting. So before we get into the issues of privacy is the overall overarching overriding topic. The issues of privacy as it butts heads with technology. I want to find out a little bit more about Mick. Hi, Mick.
Hi.
Now you tell me the story of how your journey, your evolution. You went to school down in Providence, then you went to school at the Massachusetts School of Law. So you're kind of an expert in technology, and you are an attorney. So you're able to apply the two and meld the two. Talk to me about that journey.
Yeah, that's right. When I started in technology, it was at Providence College in the early 2000s. It was a really messy time for technology. We still had desktop computers and things like that. So I started out just as a technician running around dorm to dorm, doing trouble tickets. But gradually, the threats that started kind of emerging on college campuses in the 2000s were not necessarily like I can't print my Word document. They were adware and malware and bloatware. So my first introduction to internet security really was in the early 2000s, as there wasn't a lot of internet security, and ads and malware and bloatware were extremely prevalent. So
Can I ask a question? What's bloatware? Bloat?
bloatware is they're programs that are installed alongside legitimate programs that kind of slurp up data in the background and run surreptitious or clandestine processes
Okay.
while slowing down your machine.
Okay. Thanks. And um, you mentioned earlier that before we went on the air that the field of law and teaching law hasn't really caught up to many other areas when it comes to technology, and partly because there's a conflict of interest because there's a lot of money in hard copy textbooks, and they're holding on to the old ways because it makes them more money. You can pick it up from there.
Yeah, absolutely. Well, there's actually, two components to that. One of them is that the publishing itself is really costly, and generally they take a little bit of time to truncate the cases for, first year, second year law students. They make them a little bit more accessible for them to read. But the other part of it is just generally a lot of jurists, a lot of law professors, a lot of lawyers. This is the way that they were trained. They were trained to read 50, 60 pages at a time and pick that needle out of the haystack. So it's kind of hard to change the guard in that respect without, the forced necessity of what happened the last couple years here with COVID. And now we've seen a lot of law students that want to use digital materials because they're much more capable and much more literate using technology as an aid for education.
Here's an important question. When they get out into the world and they're practicing law and they have to read real world briefs and decisions and etc., will those be issued to them in hard copy or digital? I mean, are they training in the format that they will experience in their career?
Yeah, at this point we're in a mixed mode type of environment. There are certain things that have to be filed digitally in certain courts. There are things that you'll have to pick up in paper and have to read with a paper and pen. So we're actually kind of like in the middle of that transition, just sort of like we were talking about the early 2000s or the late 90s, the transition from analog to digital recordings for artists. So generally, we're kind of in that transition point where you can use some written material and some digital material, and that's the way that it is also in courts and in the practice of law. But I do think, like I said, the last 2 years with COVID kind of forced the evolution on a lot of lawyers to have to adapt to the new way of kind of doing things, which is a little bit more of a hybrid workforce.
As an aside, I'm surprised that more businesses aren't really pushing work from home because, as you say, people were forced to become literate on with the technology that allows them to do online meetings. I don't get why so many employers insist, I guess including Elon Musk, insist they like to have their employees in the building because they have to pay rent. I don't get it. It would be so much better for the world if people telecommuted. I don't get what the advantages of having them in house is, but that's not the topic today. Today the topic is I'm curious, since we've given up so many legal rights, if we have a lesser expectation of privacy. So the formal question is, sure, we have much less privacy than we used to, but have our legal rights to privacy been diminished? Privacy rights are based on a reasonable expectation of privacy in given situations. Now that we have permitted so much surveillance by saying, agree to be surveilled, agree to location, oh yes, to Alexa, etc. And since we've agreed to so much, has our reasonable expectation of privacy been diminished? And therefore, has our legal right to privacy also been diminished? This is kind of an essay question, but you're a highly educated legal scholar. You should be able to handle that no problem.
Yeah, I appreciate the compliment very much, but you really hit the nail on the head. Of course, they have, but it really does start with our individual choices, as you kind of alluded to. We're just clicking accept, we're clicking agree because we want to get to the thing. We want it so bad that we're waving away these protections and contract and click wrap because we want to get to the thing, whether it's that new iPad or that iPhone or that new application. Part of that erosion is happening willingly and with our consent in those contracts because we want to use the service, we want to use the device. And along with those contracts are what they call third-party agreements, where they say, hey, if you want to use this product, you also have to understand that we're going to be sharing this with our partners and we're going to be doing this with it. That's part of the deal. And kind of once you allow that third-party language into the contract, the toothpaste out of the tube, so to speak.
What are some examples of these third parties? We have no idea who it is, and what are they?
Yeah, exactly.
What information are they giving them?
That's really a great identification. Is we don't really know who all these third parties are, but most of the time we're probably going to assume that they're advertisers, they're partners of Apple in development, or let's say Nintendo or Sony or Samsung. All the different brands that we use advertising partners, they use technical partners, they use all these different other vendors to help put their service or their product out. And in some respects, the goal is, in fact, to make the product better for the consumer and make the consumer experience better. But in other respects, that's really just a guise for them to collect more information that you've already assented to really bolster their market position.
So if that's the only thing, I don't have that much of a problem with it because I don't mind people marketing stuff to me that I like. And if that's really all they're trying to do, well, that's all right. But I don't believe that's all they're trying to do. Like, I would imagine you would prefer to have Fender sending you advertisements or deals on Strats and Tellys because that's what you dig. So that's not that much of a problem. I mean, maybe, well, in theory, kind of uncomfortable with it, but in practice, hey, I'm glad I got a guitar ad instead of a eye cream ad. So
yeah,
there's got to be something more insidious. How can this hurt me, really hurt me? How can it cost me money? How can I get ripped off?
Yeah, you got it right. And I would always rather see an ad for a Fender Jaguar or a Stratocaster than some type of heart medication. But generally, it's because we are essentially putting all these data points out into the cyberspace world. When I look at a guitar, when I look at a news article, all those different things, the more information that they have about my proclivities and my interests, the better profile they can build about what I like to do and how to reach me. And I think that's, initially it seems like, oh, I would rather be served a targeted ad rather than something that has no relevance to me. I'd rather have that targeted ad. They know I want to buy a Fender Strat or a Fender Jaguar, great. But the thing is, they also kind of know some more intimate details about myself that I might have revealed in a search or some type of form that I filled out on a website that doesn't necessarily have the same level of security that others have. So generally, I think it's difficult to just assume that if you're being micro-targeted and you're getting an ad that's relevant to you, it's a good thing. The profile that they can build based on your interests can be extremely detailed and reveal very private facts that you might not recognize could be correlated.
So how can they hurt us? I'm guessing it's. I mean, our fear is our bank account gets emptied, or somebody starts a. they steal our identity and they start a credit card in our name, and our financial lives are screwed up for 10 years. That's the big fear. Is that the slippery slope to that?
Well, that's just, I think, one part of it, and I think that's the short term. That you might get hacked, your financial information might be out there, that you might suffer personal financial ruin, all that kind of stuff. But I think generally it's a little bit more of a long term game. For a very long time, and you have to think pre 9/11, for a very long time, surveillance and corporations, they've always been trying to figure out what we want to buy and how we want to buy it, but we weren't always so willing to let them know what it is. And obviously once we're telling advertisers and vendors that this is what we'd like to buy, those protections from the government start to also be reduced, because we're now assenting and agreeing to say, hey, that's not that bad, I'd rather get this. So I think that generally that's the slippery slope. Is short term, yeah, you might be worried about having your bank account passwords and things like that out there, but generally what it is they'll know everything that you like to eat. They'll know everything that you buy at the grocery store. They'll know.
But that doesn't hurt me. I mean, maybe it's creepy, maybe it's creepy, but it doesn't hurt me.
Those tiny facts in aggregate will eventually reach a point of critical mass, because they're able to know the things about you that you haven't shared yet based on the things that you have shared.
For example, what type of thing that I haven't shared will they be able to glean?
Well, for example, there is this, I'm sure you're familiar with the Cambridge Analytica and Facebook scandal.
Only fuzzily.
2015, 2016. And generally the way that worked is what people would do is they'd fill out this online questionnaire thinking that essentially what it's doing is just trying to ask them what they like, why they like it, things like that. But instead what it did is it built a psychometric profile on individuals. It said, if you like Kit Kats, you're more likely to like Nike shoes. So these things can also be used to manipulate people into certain behaviors, because if you know so much about one person's interests or proclivities, that in certain respects, when you have that large data set, could also indicate that they're susceptible to this, that, or the other thing. And that's where I think where it becomes dangerous, is because the ads then can be served to manipulate behavior.
Right. And that brings us to something that's bad in a larger way, and that is inflation. What advertising does, and if they have more information about you, does it more effectively, is create a perceived need in you where you really don't have one. They create a need. Oh, I need that because, my life is not complete without a Toyota Tundra, so I can drive into the hills and live the free life just like Yellowstone. And you get this, like, you get the shakes because you need to get the Toyota Tundra. You don't need a Toyota Tundra, but they build this fake need in you. And when you watch free TV, you get all these medications and automobiles and stuff. And people start spending money they don't need to spend, and that drives up demand. And that has a definite effect on inflation, from which we all suffer now. Just an aside. Okay. Here's a question. Why is it legal for there to be surveillance cameras on the street? I have not given permission. Have I given tacit permission just because I walk? No. I mean, I don't mind them being there, but wait. Why is that legal?
Because we don't have a reasonable expectation of privacy on a street.
Who says? All right. I mean, okay. We don't have, if you define, it depends on how you define privacy. To be recorded? All right. If they've decided that, that's fine. What about me? What if I just want to record somebody on the street? Is that okay?
It depends on two different things. What state you're in, number one. Some states have a single consent requirement for video and audio recording. Some states, like our state, Massachusetts, it's a two-party or all parties consent state. So in certain respects, when you're in a public place, the general rule is you don't have a reasonable expectation of privacy in public. However, being recorded, you do have to consent in Massachusetts to the audio recording. So that becomes problematic. But again, in a lot of these instances, especially on public ways, there's no reasonable expectation of privacy. It's a lot different inside the home or inside a briefcase or inside that cell phone.
So does the no reasonable expectation of privacy in a public place override the two-party consent law? Which is it? If someone wanted to videotape someone, including audio, in public, what's the ruling law there?
Well, in certain situations, especially if it's like a public official carrying out the official work of the public in that instance, then like you're able to record. But I do think that most of the time you're looking for that second party consent or that all parties consent to get the audio recording.
So you do have a reasonable expectation of privacy when it comes to audio, and if you're not a public figure
or in a public location.
So back to the question: you're in a public location, not a public official. Can somebody record your audio?
They could record your audio, but sharing it in that instance probably could be problematic, and you might have recourse to.
So it's legal to record it, but not to share it.
Claim for the audio recording that was unconsented to, but again, that is it's a difficult thing to assess in those respects because we are kind of eroding what we think is reasonable in these moments, right? I think we talked about cats a little bit in the about the phone booth and how generally when you used to close that phone booth door, then you feel like you were in a private conversation with that person. Anybody outside that phone booth door doesn't have access to that. But these days, you see everybody on a cell phone in line at Target, walking down the street, on the sidelines at a youth basketball game or a baseball game. So we don't even think about that the same way that we did 50 years ago when cats was ruled by the SCOTUS.
Interesting. So back in the day, if the door to the phone booth was open, then you kind of gave up your expectation of privacy. But if you closed it, that is supposed to be private, probably.
And that was the general rule for quite a while. And over time, that's really evolved to, well, does the public have access to this level of technology? Fast forward about 25 years to Kylo. That's the case where essentially a Supreme Court case where the guy's potentially growing marijuana on his property. Law enforcement's using a thermal imager to try to determine what are all the heat lamps, how's this all working, so they could but if the public, and this is a Scalia opinion, if the public doesn't have access to that technology at the time, then maybe that search, it's considered a search and it's unreasonable. So now you can start to see that that's just, a 20-year gap between those two cases, Katz and Kelo. And the difference is already that, okay, well, if you close it, you have that expectation of privacy. And then the next step is, well, if the public doesn't have the ability to buy this technology or they don't have access to it, then it is unreasonable. And now we can see, like you just said, everybody's got the cell phone camera, everybody has the Ring camera stapled to the door. So if we're not expecting the same level of privacy because we've gradually told them that we don't want it, that can erode pretty quickly.
Has anybody brought suit going up to a door, saying something, maybe muttered under their breath? They got the audio recorded in Massachusetts, a two-party consent state, and they said, hey, wait a minute, you recorded me without my permission, my audio, I'm suing you. Has that happened?
Yeah, that's something that we're going to have to probably dig a little deeper into. But as of right now, there's nothing that's at the level of the court or the SJC here in Massachusetts that's really been enough to say, here is the new standard. Sometimes those things kick around in the sandbox in the district court and superior court level as claims. But the most recent Massachusetts case on that really is a 2014 case called Polay versus McMahon. Similar, but now, again, we didn't have the Ring doorbell back in 2007 to 2014. And again, this is a 2007 case. It happened in 2007, but it wasn't ruled on until 2014. So there's a 7-year gap between the incident that happened and when they actually decided what was going to happen in the case. In that instance, what happened is a homeowner aimed a bunch of their digital cameras at another home that actually could see inside the windows of the home. Now, the exterior of the home and a certain level of recording to protect your own property, that's reasonable. But at the point where you start aiming those cameras at other people's homes to see what they're doing or inside their home, that's when you can kind of have an invasion of privacy or an IIED claim stand.
So that's interesting. It would seem natural to me, and it would seem you could certainly make the case that anything that you can see with your eyes from your own home should be fair game for a camera. It's just another way of seeing remotely. You're not seeing anything else that you wouldn't see just looking. Why can't you make the case that even if that happens to be in somebody's window, yeah, you have a window. You don't have, I don't, if I can see that from my house, no law against that. What all of a sudden about a camera makes it illegal?
Right. Well, I think that that's the distinction there in Polay, is that like the purpose of this was that the defendants and other people in the neighborhood, they were alleged to do this for the purpose of harassment. So in a lot of respects, the ring concept, just putting it on your door to make sure that you're not having your packages stolen or to protect your property as a deterrent, that's considered a reasonable use of these things. But that escalation to kind of aim the camera, point the camera into the home, that's where the SJC drew the line and said, no, this is exactly what we're trying to protect against.
So that had to do with motive.
Yeah, well, a little bit of motive, but also the fact that the protections of the home are the highest protections given by the Fourth Amendment. Generally,
But you have but all that. If you were just protecting your home, then you would
be all right. You got it.
So then it is motive. If you can prove, well, yeah, I can see in there, but I'm just protecting my home. It's incidental. Live with it. Deal with it. I mean, I can see in your house anyway. Everybody can see in your house. To take this a step further, I did a little research, and I didn't research this specifically, but it popped up. In a common area of a building, you don't really have an expectation of privacy in a common area. And this is what I read. I don't know if it's true. It's just interesting that even when somebody opens the door, anything that can be seen incidentally from a common area, that does not, in any area that can be seen even inside the apartment with the door open, if you're in the common area, the person doesn't have an expectation of privacy there. Like if you go in the doorway, open the door, somebody's walking by and they happen to look at you, you don't have an expectation of privacy in that area which can be routinely seen. Just as an aside. I don't know if that's true. Does that make sense to you? Have you heard that? You read that?
Absolutely. In what you just mentioned, actually, those two things tie together. Incidentally is the key word there. Whereas like deliberately, you said earlier, motive. That's kind of what happened in McMahon, is that like the actual intent was to cause this person emotional distress. That's why it's called intentional infliction of emotional distress, because there is an intent requirement. So if the motive or the intent is to invade the privacy or cause emotional distress, then yes, but incidentally, that's a different situation. And I think that that's why you see homeowners associations or condo associations providing really flexible language in those agreements with their tenants and their homeowners.
Right.
Say, yeah, like you can do this, but as long as it's a reasonable use of the camera to protect your own property or your own interests.
Right.
Yeah.
So that Wayne says that would be the plain view doctrine. And I guess the plain view doctrine is also used in traffic stops, etc. If, which is why if you have something you don't want the authorities to see, don't keep it in the glove compartment with your license. Because if you open the glove compartment to get your license, and there has to be some contraband in there in terms of drugs or weapon or whatever, all of a sudden they don't need a search warrant to say, oh, look at that.
Yeah, it's one of the exceptions to warrant requirements. You got it.
So there's that. It's all pretty interesting. Next, so I don't forget, two things back to internet privacy. One, fine print. It seems that fine print is used has been weaponized. It's not just, hey, we have a lot to say, so the print is small. I would say that they are definitely hiding things in the fine print.
Do you read that?
There's got to be a law about what is reasonably expected to A, understand, B, to be able to wade through. There should be speaking of plain view doctrine, there should be a reverse plain view doctrine that says you have to make anything to do with a compromise on your privacy in plain view in large print. Like even a special pop-up box that's dedicated to that. if you don't do that, then it's illegal. That's what I want to see. Is there anything getting close to that?
Yeah, and there's a whole lineage of cases on click wrap contracts and making certain material terms of that contract conspicuous, making sure that the end user scrolls all the way down to the end of that EULA or TOS to essentially confirm that they've actually scrolled through it rather than just click agree. Those cases have been around for a really, really long time. But the problem is like you said, how often do you actually read every word on one of those terms of services when you install a new application on your phone or on your iPad or on your laptop? And I would say that generally, like the general public does not really read through that. And if they do read through that, the access to the language that lawyers use is not really something that a person that's a non-lawyer could understand what that means.
And plus, there's a sheer volume of it. It's the sheer volume. You know, when people do document dumps to hide stuff, it's like that.
Yeah, it is like that. And I think that there is a general fatigue that comes along with, and you could talk to I talk to them all the time. You could talk to a law student about trying to read through all the things that a case says just to find the one sentence to locate that rule. It's the same thing with these click wrap contracts. The details are in fact buried in the fine print. And I have my issues in internet law, and law office technology students do this all the time. I have them pull up their favorite smartphone app, Spotify, whatever it is. So Spotify is a good one for this, because a level of surveillance embedded in Spotify is truly astonishing. And generally, that's what they find is they find that in their Twitter TOS or in their Spotify TOS that they've agreed to arbitrate every dispute that they have, 7,000 miles away, someplace else, sometimes in California, sometimes in Florida, sometimes in Delaware. Second year, third year law students, they're trained to do this. They're still shocked that they cannot bring a claim in their own state where they're injured by this, because they've actually waived away the ability to contest it any other way than arbitration.
So tell me about Spotify and the compromises you make to use Spotify, because I use Spotify. What did I do? What did I give up?
So generally, it's not just Spotify. It's pretty much anything that is going to give away some element of what we're interested in, how often we do it, where we like to do it, what we like to do when things happen. The devil's in the details there with Spotify and some of these other applications. But with Spotify, it's usually an issue with a microphone permission, believe it or not. And why would Spotify need to access your microphone?
To spy on you.
Well, that's right. I think that, plainly said, it makes you wonder why they need to access the microphone. Now, if you want to, give permission for microphone use in certain respects because you're using Siri or whatnot to dictate, or, you're driving and you want to use CarPlay, these are all the different ways that we might be turning on or allowing microphone permission without recognizing that we have. So the other thing is that you've really kind of just backdoored your way in is that idea that they're asking for permissions that they don't actually need access to, and we're saying yes to because we're just so eager to use the service. So that's the problem there. You got it.
So is it all or nothing with those things? If you don't agree to all of the restrictions or whatever the permissions, then they say, sorry, you can't use us?
Yeah, I'm going to give you a great legal answer here, and it depends. In some respects, sometimes, as soon as you let the genie out of the bottle, it's out. In other respects, you can kind of say no to those permissions as you install and turn them off. But again, it does require a high degree of literacy, technical literacy, to kind of go back in through the settings on that iPad or iPhone or other device and make sure that the applications that have requested access to your camera or microphone actually in fact have those permissions turned off while the application's in use. So it does depend on the application. It also depends on the end user being able to identify what those permissions that were asked for were and how to disable them after the fact in settings.
Actually, at this point, everyone needs to assume that everyone can hear everything you say all the time. Really. Might as well make that assumption,
I think that's good to assume there's a zero trust environment.
Zero trust environment. I've had minimal trust for a long time. I'm going to notch it up to zero trust on your suggestion. Next, is a VPN worth it? I guess the main thing is, do they clunk out? I really need the highest speed I can get. I mean, maybe I have extra, but does it slow things down noticeably? A VPN? What is a VPN?
It's a virtual private network. For for those at home, virtual private network is designed to essentially shield some of your internet activity, your IP address, and other things that you're doing while you're connected to the internet from the general view of people sniffing packets, general
People doing
ISP.
what? Snipping packets?
Packet sniffing. Sniffing packets is
What's that?
technical terminology. Essentially, it's like standing outside somebody's house and like watching the mail come in and out of that person's mailbox, but kind of getting a quick peek at what is on the envelope. So to speak. So every time you download, let's say, Bradley, you're interested in a show like Yellowstone. I've heard you mention it a couple of times. You download a couple episodes of Yellowstone, but one of those episodes is like not just like one brick of 1.2 gigabytes of data, but hundreds and thousands of tiny pieces of information that all get reassembled on the other side to present Yellowstone to you here in Boston. In every single one of those packets, those pieces of information, think about Scotty, beam me up down to the planet. Every piece of that information comes together on the other side, but you might be able to infer other things about the routing, about the computer that person's using through that packet transmission. So generally packet sniffing is one of those areas where that can occur, but also generally it's the VPN will shield or hopes to shield some of that traffic and some of the information that's relayed in that traffic before prying eyes can see.
Is there some group of people on the other end, actual human beings, that are gathering this information and sniffing the packets? Some room of people in their underwear in Russia, or just humanly like recording this information, or is it just done by machines?
No, I think that you're probably right again, that there are both machines doing some of the work to identify things that are of interest and then are reviewed by analysts, whether they're state sponsored or they're crime rings. But both of those things are the people that would be interested in what you're doing, because again, foreign governments do seek to try to influence our behavior. They try to exploit our differences. They try to figure out what we like and dislike about each other and drive a wedge through internet manipulation and disinfo.
Right.
So all those things, really, you can get some of that information from sniffing internet traffic and what people like to look at and why.
To give you folks an idea of how damaging this is, foreign actors do figure out if you're a Republican or a Democrat and will feed you false information to radicalize you. And as a result, that contributed to January 6th. So back to the VPN. Does it slow down your system significantly?
Again, that really depends for a lot of people. And I think, these days, nobody's trying to spend $3,000 on a computer with 16 gigabytes of RAM. But generally, it really does depend on the ability of the machine that you're using to kind of keep the VPN, keeping its shields up. We keep kind of referring to the Enterprise, the USS Enterprise, and it's a really great analogy.
I don't. You do.
Yeah, well, hey, it works, and I know it's a great vehicle, both in space and for conversation, because that analogy is really spot on. Essentially, the VPN is
shields up. All right, I'm thinking about getting one. What I hear you saying is, if you have enough headroom in your internet speed, then maybe.
And your computer processor, yeah, exactly.
My processor, probably okay.
Yeah, and encouraged.
So it's a good thing.
The right ones, yeah.
What's the right one? What's the best one? How about Nord?
I work for a nonprofit organization. I'm not able to make an endorsement. But I would say that generally, reputable VPNs you can find on Google. And for the most part, the goal of those is to anonymize some of that traffic, especially if you're working in a sensitive field. But also, if you work for an organization and you're working remotely, organizations should have corporate VPNs to make sure that their employees can log in securely to meet the expectations and requirements of their.
I think it's cool. I actually am going to look into it. Here's a question you can't answer, even though you're part of a nonprofit. What is the most popular? Because that's simply a fact.
Yeah, I think that you're right to assume that the most popular one is NordVPN, but even that has some issues there because of where some of the operations are located, where the servers are located, and whether or not things that occur where those things are stored is always protected the same way. And I think that we have that same issue when we're talking about the Ring and the Alexa. Is we assume that all this stuff, we're in privity, a contract with Amazon, they're storing our stuff in a thing that's just labeled Mick Coyne and nobody can access it but the authorized personnel at Amazon and Mick Coyne. Well, you would be wrong about that as well. So
Right. Well, something interesting about a VPN, an interesting use. I follow the conflict in Ukraine quite closely. There are two particular podcasts that are wildly popular, like 400,000 followers. One is Jake Bro. He's located in the States. But the most popular one is Denis, Denis Davidoff, who broadcasts from Ukraine. And he has to, of course, use a VPN to protect himself. And I don't even know if he could get out without a VPN. But people in Russia, I mean, if you live in a country that is not free like Russia, you can't, and you want to get outside information or even have full access, you need a VPN because that disguises your location, which I think is super cool. One more question about that. What do you call it? Incognito. The incognito window.
Mm-hmm.
That's VPN Lite. What does that protect you from? Does that do anything at all?
Yeah, well, similar. Yeah, VPN Lite is one way to refer to it. It does. It's supposed to disguise and encrypt some of your internet traffic. That way, the most basic kind of cyber criminals or advertisers don't get a peek at everything that you're doing. But at the same time, if you're talking about trying to protect that from the Russians or the CIA or the NSA, like that's not going to do it.
And am I right when you use incognito? That means every time you have to type in the URL. Every time you have to either type it or
because it hasn't stored it or cached it. Yeah,
which is
but again, that's Bradley. That's
I know.
That's the convenience for the security, right? That's our
yeah, I know.
Quote, right?
So is that the same with a VPN?
It depends. Again, with the VPN, different VPNs will require different types of security layers or different types of behaviors. You can obviously augment the settings to your own liking. But again, this brings us home really to the main thing that has to happen is we have to take responsibility for our own data privacy, both in advocacy and in our behavior.
Right.
The UK and the EU have much more stringent data protection laws. They have the right to be forgotten. They have GDPR for data breaches. We need a comprehensive legislation, not just to, understand how to better protect Americans' privacy, but how to educate Americans about how to advocate for better privacy protections. One of my friend, Evan Greer, his organization Fight for the Future, recently wrote a letter to Amazon and MGM about the Ring camera and about the level of surveillance network that they're essentially trying to entertainment wash to normalize the behavior. So generally, that's where we're headed.
Okay. Pretty much. What was I going to say? Something crucial. No, I guess. Oh yeah, just that. I'm flying around. I share like this interview, for example. I'll be sharing it to every platform because it's part of it's what I need to do, and I'm gonna have to type in everyone, or maybe I can have just a Word document with the URLs and I can cut and paste them in. But you're right. Oh, I know the key thing I had to say. The reason that we lag behind other countries, twofold probably. One, a lot of our legislators are old and in the way. They just don't get it. They don't understand. Two, lobbies. The big tech lobby probably lobbies to keep those kind of new laws off the table. Yes.
Yes and yes. I think, we do have some. I will, volunteer our own senator here in Massachusetts, Ed Markey, as being way ahead of the game on internet privacy in comparison to the rest of the legislature. Senator Mark Warner up in Vermont. We've got quite a few that are very hip to this. and are, interested in internet reform. This is not this 230 reform. This is privacy reform. This is real reform, and necessary reform. And generally, I think that is where we've got to go. We've got to make sure that we can start to codify some of these protections before they erode too far, and we agree to erode them with our own consent.
Yeah. Okay. Let's go back to the original. As we finish up, let's go back to the original question, and get the answer that we may have pulled together from all this talk. I'll read the whole thing exactly the same. Sure, we have much less privacy than we used to, but if our legal rights to privacy been diminished, privacy rights are based on reasonable expectation. Now that we have given up so much privacy and permitted so much surveillance on the street and online, has our reasonable expectation of privacy, and by extension, our legal right to privacy, been diminished? If yes, to what degree?
Yes, because we've agreed to diminish it for the sake of that convenient phone call on the sidelines of the soccer game, for that, whatever it is that we're agreeing to before we've read the contract. We've done it to ourselves.
So the larger question is, will those permissions extrapolate to other cases that haven't really been adjudicated yet? Will they be able to say, look, you've given up that, and you've given up that, and you've given up that, and we say Ring doorbells are okay, then this other thing, since these precedents have been established, even though this hasn't not been decided yet, will be used against privacy to decide cases that have not yet come up?
Yeah, and I think that you're kind of right to assume that those cases might be in the hopper right now, but we won't even see a precedent set for another 4 or 5 years, because they usually take 5 to 7 years to get all the way through appeals. And then at that point, maybe it's not even a live controversy anymore, and they're really just kind of ruling for the parties, because the legislature has kind of come in and made a determination and made a law on their own. But again, we've been in this phase now for about 10 years, waiting for some true internet legislation reform, and it's not forthcoming. And I think that it's going to take a lot more advocacy to kind of overcome the Silicon Valley lobby, as you previously mentioned.
All right. Thank you very much. It's Mick Coyne, Director of Technology at the Massachusetts School of Law, my favorite school of law. How are things over there? Do you love it over there?
Thanks. Yes, I do. I love it.
How is it different from other schools of law? Not regular. It is regular, but how is it different? I get this positive vibration whenever I deal with anybody from there or when I go there. Can you talk about that?
Yeah, I think the only thing I would say is that we really kind of do give everybody a chance. And, for the longest time, and you can tell from if you look at some of these websites, and some of these law firms, you're looking at a very homogeneous pool of talent,
Right.
on the top levels of those boards and in those law firms for partners. And for us, we really try to make sure that we're being an exceptional at access, providing the opportunity to that education for anybody that's willing to work hard for it, regardless of your background, your upbringing, your race, religion, all that kind of stuff, wherever station of life you're in. We're trying to be as affordable as possible, so we can really keep our doors open to anybody that has the time, the energy, and the fight, to try to break through this profession. And generally, we do need more diversity, both in experience and in background, to really effectuate change at the legal level.
My brother also loves it over there. He sometimes is on the edge of saying, "I think I should go there." If
We'd love to have you.
they would
Stop
have
by
me.
anytime.
So next, I see you have Fenders in the background. You're a Fender person as opposed to a Gibson person?
Yeah, I grew up with all the Nirvana records in my Discman.
So what do you have back there? You have a I don't want to say pink, a pink Strat.
It's a shell pink
That's
Strat.
pretty-
I actually put that together for my daughter. I like to kind of put them together every now and then. I'll buy one every now and then that's already, the way that it is. This one actually right behind me has the best story. The Black Jaguar. I sold it in 2009 to buy my wife an engagement ring. And it just so happened like 2 years ago, I found it on Craigslist. The
You
kid had sold
found
it.
it on Craigslist.
Yeah, it's the kid I had sold it to somebody else, and I was just able to get it back. So this guitar right here, the Black Jag, was missing, gone, sold it for 500 or $600 to supplement that wedding ring, and
That's cool.
came back 10 years into our marriage. It was pretty great.
How is a Jaguar different? Like the feel of it, the sound of it. I don't have any experience
Well,
with
that
Jaguars.
Jaguar is very different, and I mean, I could go days on end telling you how that Jaguar is different because it's a double humbucker. Jaguar is a really heavy guitar, but that one has like a really screechy sound. So, a regular two single coil Jaguar sounds something like Johnny Marr. If you're a Smiths fan, I'm sure you're a BCN rock jock, so you
I'm a
know
Johnny Marr. I'm a Johnny Marr guy.
so that's that sound. The green Jaguar over there rather. That's that Johnny Marr kind of sound. Or Beach Boys. Like you can get a large swath of sounds out of the double singles there. But the two humbucker Jag, screechy sound. That sounds like Melancholy and the Infinite Sadness, Gish, Machina. That's a very noisy guitar, but it's great. It's very.
Do you
nice.
also prefer Fender amplifiers?
No, I've got Orange and Vox amps.
Interesting. How do you make that choice?
Oh, that's what saves the day, and Tom Petty played, so I always kind of wanted to get a little bit of what my favorites always were using on stage and try to get that sound. So generally I'm a sound fiend.
I've been watching a lot of guitar. I love YouTube, and I learn so much every day. And I did watch this documentary on the Marshall Amp Company and how Pete Townsend was instrumental in working in the early days of that. But I guess in the very early days, Vox was the very first, right? Weren't they the first, among the first out there?
Well, that's really the classic UK British amp sound. If you look back at all the early Beatles recordings of them on Ed Sullivan's show, you look behind them, and there are the Vox AC30s, which is like the classic amplifier. So yeah, in a lot of respects, we didn't have electric guitars really before the 1950s, 1960s, and Vox ended up. That's what the Beatles played. That's what everybody wanted to play. Just kind of like how I grew up. It's like, well, Kurt Cobain's playing a Fender Mustang. That's what I want to play. Kurt Cobain's playing a Fender Jaguar. That's what I want to play.
How much do you practice?
Not as much as I used to. I'll tell you that. I got 2 kids, and work keeps me very, very busy. But I still do some gigs sometimes.
You do gigs. Wow.
Do a lot of studio work, and generally, if I wasn't involved doing music continuously, I don't know if I'd be able to get through all the other things I've got to do.
Do you have a band?
Yeah.
And what's the name of it? I have to get the name out there.
Oh, all right. Well, I don't want this to turn into one of those shameless self-promotion.
No, but I asked, so
yeah,
you're off the hook.
Our band's called the Ringer Soundtrack.
The Ringer
Soundtrack.
Soundtrack.
And we still gig from time to time between Rhode Island and Boston. So
cool. And finally, you're a tech guy. You say you do studio work. Do you use Logic? What do you?
So your programs? Yeah, exactly. I use Logic. For a long time, I kind of like chased that Pro Tools kind of thing because I wasn't as good a producer as I am now. When I first started out, I really was just a punk rocker, and whatever I could get onto tape, I was thrilled that I could listen back to it in my car. But now, yeah, Logic, nice microphone, and you're ready to go.
Yeah, I just finished an album on using Logic. I live in Logic. Hey, one final thing. Have you heard of a thing called Lander?
No, I haven't.
All right. So for you, this is going to be huge. Then I promise we'll go. It's up your alley because it involves AI. It's an AI online mastering tool for your song after you've done it in Logic and you've bounced it down to a nice WAV file. And you want to master it instead of sending it off to Bob Clearmountain for $1,000 a track. He's probably dead, but instead of paying thousands of bucks for mastering, this LANDR allows you to simply even before you pay, take your track, just drop it on the thing, and it masters it. It compares your WAV file with the WAV files of top 10 hits. It optimizes for streaming. It does all kinds of things. But at the other end of the tube, it sounds way better. And it's so cheap. You got to check out LANDR.
I'm going to have to try that out tonight. I've been using an isotope plugin to do that for the last little bit, but I'm going to give that a shot. I've got a few things that are in the hopper that I'd like to hear.
So you can check it out. And it allows you to A-B them. You can hear the original side by side with the new one. It generally makes them sound fuller. And if for some reason you don't like the way it sounds, there are parameters that you can, in a very simple way, not a real deep way, like low, medium, high on EQ, low, medium, high on the strength of the compression, the intensity of the compression. So Lander, love it. Check it out.
Thank you for the recommendation. I can't wait to try it. Thank you for having me.
Of course, Director of Technology, Massachusetts School of Law, and beloved son of Michael Coyne at the Massachusetts School of Law. Thank you so much. You did a fantastic job.
Thank you, Bradley, for having me. Have a great day.
Talk to you soon. Make sure everybody you share this. Bye-bye.
Bye.
Okay, we'll be